Hello, my name's Joanne Staphnill. Welcome to my podcast for totallylegal.com. I'm a senior solicitor at the boutique firm Robin Simon LLP. At Robin Simon, our business is protecting the professions, so we've defended legal professionals in claims arising out of every scenario you could think of. In this series of podcasts, I'll be sharing my top tips to help make moving to a new legal job as pain-free as possible. Sometimes it can seem that all the risk management advice out there is aimed at fee-earning staff. And that's hardly sensible, given the vital roles played by legal secretaries, finance, HR and marketing professionals. So in this podcast, I thought I'd redress the balance a little and share a story that might be of interest to legal marketing professionals. I acted for a firm which employed a very experienced marketing executive. She'd done great work on the firm's marketing strategy. In particular, she'd pushed for the firm to publish more newsletters and took a limited editorial role to make them as fresh and punchy as possible. And that's no mean feat given how verbose lawyers can be. One day, one of the firm's lawyers gave her a draft commentary on a recently decided case. The firm hadn't actually acted in the case, but it was an important one for that practice area and well worth writing about. The case decided a preliminary issue, which meant that the court was deciding a pure question of law first, assuming certain facts in favour of the claimant, and would have a separate trial later if necessary to decide the facts. The lawyer's draft did explain this, albeit in a rather wordy way. The marketing executive made a couple of changes to the draft to make it a bit more concise, then published it on the firm's website and emailed it to everyone on its database. Unfortunately, the result of the seemingly innocuous changes she'd made was that the commentary now arguably gave the impression that the claimant had already succeeded in proving its very serious factual allegations against the defendant. The defendant found out about the firm's publication and threatened defamation proceedings. To resolve this claim, the firm had to publish a correction and apology on its website and by email. Clearly, this wasn't the sort of publicity the firm really wanted. As marketing professionals know, it's now common practice for organisations and individuals to use internet search engines to monitor their online presence. They will take action to protect their reputation and brand. Anyone applying for a legal marketing role might be able to get ahead of the competition by demonstrating an understanding of the potential risks when firms publish marketing material. It could also help to show familiarity with some of the strategies to minimise those risks, such as ensuring that all publications are reviewed by someone with the expertise to spot defamatory remarks or legal errors. I hope you've enjoyed this podcast. Keep an eye on the Totally Legal blog for more from me. You can also find me at robinsimonllp.com or on LinkedIn. I wish you all the best for a successful and risk-free job search. This brief summary should not be applied to any particular set of facts without seeking legal advice. The copyright in the content belongs to Robin Simon LLP, which is registered in England and regulated by the Solicitors Regulation Authority. This podcast was recorded at Alaska Studios, London.